Ladies and gentlemen, I welcome all to my channel. I am Raziaq. Today we are going to discuss about the new Rent Control Act, which is known as Tamil Nadu Regulation of Rights and Liabilities of Landlords and Tenants Act 2017. It is simply called as RLT Act, Regulation of Rights and Responsibilities of Landlords and Tenants Act. Previously in Chennai and in all over Tamil Nadu, there was an act called Tamil Nadu Building, Lease and Rent Control Act. The previous act was totally protective and favorable to tenants. It was not easily possible to evict a tenant under the old law, and it will take a long time, and the landlord has to process a long process. The landlord has to spend enormous amount, and the landlord has to wait for a long time, and the landlord has to face multiple proceedings under the old act, as the same was protective of tenant and their rights. Now, as per the new act, the time of proceedings is minimized. The process of inquiry is minimized, and the sort and shout speedy procedure is mentioned, and so the landlord can easily file a petition for eviction and they can get an order within 90 days. The act itself says any application made under this act should be disposed of within a period of 90 days from the date of filing of the petition. So section 36 of the act says all applications filed under the act should be disposed of within a period of 90 days, that too from the date of filing of the petition. So normally, as the proceedings and process and the inquiry procedure is shortened and speedy procedure is incorporated under this act, the landlord can easily file a eviction petition and can evict the tenant within a short period of 90 days. Even if the case prolongs, it will not go beyond 6 months, and within 6 months or maximum within a year, a landlord can easily evict a tenant under the new act. So, in order to get the benefit under the new act, the act stipulates certain conditions. The sections 4 of the act says there must be a registered rent agreement. So, without a rent agreement, we cannot approach this honorable court. So that is the must for the act. Secondly, the registered agreement should be a registered one. It is not necessary that this agreement to be registered with the sub-register office. There is a difference between the registration of the document with sub-register office and with rent authority, prescribed under this Landlord and Tenants Act. If you go for a registration with sub-register office, you will have to pay stamp duty, registration charges. The stamp duty is around 1% of the total rent payable to the lease period, and the registration charges is also around 1%, or a minimum charges, whichever is less, has to be paid by landlord or tenant during registration. This is the procedure for registration of a document with sub-register office. This act does not stipulate that this needs to be registered with sub-register office. This act says that this document should be registered with the rent authorities prescribed under the act. So the process and the procedure of registration is also very simple. It can be done easily through online by making a meager payment and following the same. So the rental agreement written rental agreement and the registration are the basic element required to every landlord to approach this rent court and to file any eviction petition or to get any relief under the new act. So if you file a case under the old act, it will take a long time, but when you file a case under the new act, it will not take even 3 months for its disposal. The Act says, the Act section 21 stipulates various grounds. One of the grounds is that if a landlord or tenant fail to execute the rent agreement, on that ground itself, the landlord or tenant can file a petition for eviction. So the other grounds includes eviction for failure to pay the rent, and tenant parted with possession, tenant misuses the premises, premises required for carrying out repairs, premises required for rebuilding, alteration, demolition, and tenant building required to the owner for owner's occupation, or the other grounds available to the landlord to evict the tenants. So there are about 6 or 7 grounds. So by using any one of these grounds or one or more grounds, the landlord can easily file a petition and get an eviction order and evict the tenant within a short period of time. Under the new Act, the procedure to be followed is specified in section 36 of the Act. The section 36 specifies the speedy procedure. So under the new Act, if a case is filed, it automatically the party of the first hearing itself, the copy of the petition with documents is served to the other side. On the next hearing date, within 15 days, the opponent has to express his counter statement or objections with documents, and the third hearing, the case is automatically posted for arguments, and automatically for the next hearing the order is passed. So in old cases, in old procedures, the parties were expected to give evidence. The party will come to the court and they will come to the box and they will give evidence. Then the recording of the evidence will take a long process. It's a long process. It will also take a long time. And then the party will be cross-examined by the other sides. Then petitioner will produce 3 or 4 witnesses. Then the different opponent will produce 3 or 4 witnesses. Then so the time will automatically go on and it will prolong. But now the giving of evidence is totally stopped. Cross-examination is totally stopped. So there is no evidence, no cross-examination. Automatically the case is posted for argument. One more important thing is that the court officer can decide the way of conducting the proceedings. He can, if in one case he may allow the filing of proof of evict, and in one case he may disallow the filing of proof of evict, because the discretionary power is given to the court judge who is conducting the proceeding, whether he can allow the proof of evict or the cross-examination. So as a matter of right, the parties are not entitled to claim cross-examination which was prevailed in the previous period. In one case, this is a case law. This is a case law of in CRP PD number 2807 of 2021. CRP PD number 2807 of 2021, passed by Honorable Justice Subramanian. In this judgment, the High Court has categorically stated that the parties are not entitled to claim the cross-examination as a matter of right. In this case, in the original court proceedings, the respondent filed an application and seeking the permission of the court to permit them to cross-examine the witness. The court below disallowed the petition and rejected the petition, as against which the tenant appealed to the High Court and asked for a direction from the High Court to direct the lower court to permit them to do cross-examination. The High Court in its judgment categorically stated that the object of the Act is to conduct speedy procedure. So, the parties are not entitled to claim the right of cross-examination as a matter of right. So, the lower court below can, in its discretion, can decide whether he can allow cross-examination or not. So, in this instance case, it was rightly applied. So, the High Court has held that the party is not entitled to for cross-examination, and directed the court below to conduct the case and furnish the judgment without any cross-examination as taken in its as per the decision which is taken by the court below. So, under the new Act, the new procedure stipulated makes the parties to get a judgment, and it makes the landlord or owners to file an eviction petition and get a judgment on order or eviction order within a period of 90 days, and they can easily evict the tenant through the court within a short span of time. So this Act, I wanted to make one more clarification. This Act came into force on February 2019. So though the Act was passed in the year 2017, it came into force on February 2019. So the Act under Section 4, it expects that there must be a written lease agreement for every tenancy. So if there is no tenancy, if no agreement, then the parties cannot approach this honorable court. And this Section 4A also stipulates that every rent agreement should be registered. If it is not registered, it will not be taken into evidence. So this Act, as per the Act, it expects the parties who came for tenancy after February 2019, they have to make the document registered. They have to make a written rent agreement, and it is to be registered with the rent authority. Supposing a tenant came before February 2019, then the Act says that the party should register. The party should make a rent agreement, and they must register it within 575 days from the date of the Act came into force. So within 545 days from February 2019, every party should make a rental agreement, and they must register it with the rent authority. Supposing the tenant failed, they did not come forward and avoided to make any such rental agreement, the Act under Section 21(2)(a) says that on this ground itself, the landlord can file a petition and they can evict the tenant on the ground that the parties failed to make a rental agreement. So the failure to make a written rental agreement is also one of the grounds for eviction. So on the ground itself, the landlord can evict a tenant under Section 21 subclass 2A. So, supposing the tenant came before February 2019, so before the Act came into force. So the Act, there is a judgment of the High Court which categorizes the tenancy under 4 or 5 heads. And generate the High Court judgment. I will make a separate video about those judgment in detail. However, I wanted to share the nutshell of the judgment through this video, which will be very useful to all the tenants, or to all the viewers who are watching this video. So, as per the judgment of the latest judgment of the High Court, if a tenant came on or after February 2019 and failed to make an agreement, then they are not entitled to file any eviction petition under the new act. So, if the tenant came to the premises after February 2019 and there is no rental agreement, they cannot file any petition under the new act, and they can go to the civil court and they can file a suit for ejection suit, and they can get a civil remedy, that is a long time processing remedy. For all the other tenants who came and occupied the premises and who failed to enter the lease agreement and expired, or who failed to make an enter agreement, can also file a eviction petition under a new act on the one and only ground that the tenancy agreement was not made and tenant failed to make an agreement. So, the provisions and benefits of this act is also available to all the landowners whose premises were taken by tenants on lease prior to February 2019. So, they can file a eviction petition on the ground that the tenant failed to make a rental agreement, and on that ground they can file an eviction petition and they can get an eviction order within a short period of time as per the speedy procedure and shortest procedure incorporated under the new act. So, this new act is a gift to the landlords and owners. And so, on the other hand, the earlier act which is a protective to the tenants, is not available right now. So, if you are a tenant, you will have to adjust with your landlord. Otherwise, they can use this new act and they can evict you through this speedy method. So, if you are a tenant, I advise you to go amicably with your landlord. And if you are a landlord, please consider the problems, the worries, the other issues of the landlord or tenants, and give them a reasonable time and opportunity to correct their issues if any, and also give necessary time for their vacation so that they can comfortably move to other places. Under the old act, it was fixation of fair rent and restoration of amenities and various other reliefs are there. But under the new act, under section 9 and 10, if the landlord wanted to revise the rent, it will be revised as per the terms and conditions mentioned in the rent agreement. So, supposing if you have put a revision clause in the rental agreement itself saying that the rent shall be enhanced by 10% every year, so it will be automatically enhanced. So, for that, every 3 months before the enhancement, the landlord has to issue notice stating that as per this agreement, this rental agreement rent shall be revised with effect from so and so date. Automatically, it will be come into effect. If the tenant fails to pay the enhanced rent, then landlord can file a petition under section 10 of the Act before the rent authority, and they will automatically fix an order fixing the enhanced rent as per the terms and conditions mentioned under the new Act. I hope this video is useful to you. So you can see various of other legal topics videos of mine, which is available both in Tamil and English. If you all wanted to see my videos in Tamil, you can watch my Raziaq Sattam Arivom, and you can watch, you can click and open my Raziaq Sattam Arivom Tamil channel or Raziaq Law Tube, which is an English channel, and you can click any of the topic, and various videos covering various topics are available. I hope those videos will clear your doubt and you can equip yourself by seeing and developing your knowledge. In addition to that, if you have any specific doubt, you can always contact me to my cell number, and you can give my legal opinion or consultation, whatever is required to you. And I hope this video is useful to you. And I request you to give your comments on this video, which will be helpful to me. And if it is useful to me, if it is useful to you and or your friends or family, you may also share this video to them, and you may give your support to my efforts. I will come again with another topic. Till then, goodbye. Raziaq.